Children and Family Services. You have up to 10 minutes.
I sense as none of the lawyers had a chance to say what they came prepared to say today, so I'm going to knock you off the rails here. It's a little unclear to me what limitations were placed on the expert, Ms. McMahon, if any, by Judge Trent-Acosta in connection with Ms. McMahon's report.
In terms of the sanctions, when she was limited to within her revised report?
Was there any order in advance that's in the record that says you can do your report, but you can't interview Lexi, you can't do this, you can't do that? Is there anything in the record on that?
There is. Basically, Judge Trent-Acosta did not want this child over-examined by a bunch of different experts, and so that's why we had one agreed upon expert. And the understanding was, although I will admit the order is not as clear, but was that this child was not to be re-interviewed and reassessed, that we would have the one expert. And not only that, there was an interview and bonding assessment of the child done without consultation with her attorney. So that was the second part.
That's my next question. So she has counsel.
Yes.
And having done hundreds, if not thousands, of dependency cases, for the first time the question arises in my mind, what authority do the various parties have to talk to other people in the case? For example, the department is the petitioner. The department is a party, but the department talks to people who are represented by counsel all the time. You talk to mothers, fathers, children, etc. So what is the department's authority to talk to people represented by counsel?
We regularly talk to parties without counsel unless they state, or there's an order, or counsel tells them, you cannot discuss this matter with my client without counsel present. Then we have to refrain from doing so. And that would be the same with the minor. If the minor's counsel said, you cannot talk to my client without my being present or permission of the court, it would be the same thing. But otherwise, it is more laxed, because we are an arm of the court, and part of our duties is to conduct an investigative function for the court. And so we do really talk to parties unless we're told not to discuss the matter without their attorneys present.
So is there any published authority in California on the subject of any party speaking with another party in a dependency action who's represented by counsel? Other than the general state bar rules about not talking to somebody else's client?
I'm not aware of any published authority on that issue. However, Evidence Code Section 5.546 allows a court to issue evidentiary sanctions if an action is taken in terms of the manner that discovery is received. And the court found that Ms. McMahon did violate orders by conducting a separate bonding study. But putting that aside, I think what's important is twofold. First, given the standard of review, the substantial evidence test, the quintessence of which is for this court to look to see if there's any evidence supporting the orders actually made, not an examination of evidence that could have taken the court in another direction. And so the question is, was there any evidence to support the orders actually made? And there were. We have the therapy reports, we have the position of the guardian ad litem, and we also have the agreed upon court-appointed expert. And the other thing is, if you look at the McMahon report, we have to look at it in the context of the information she received when making her determination. The sole information she received was from the foster parents and observing the child in the foster home. And if anything can be taken from this record, and frankly from the briefing, is that the foster parents present a very skewed narrative. So Ms. McMahon did not interview the therapist, did not interview the guardian ad litem, did not interview the social worker, did not interview the relatives, and did not observe the child with the relatives, yet took a very rigid view based on a skewed narrative. And
let me ask you about that if I can. So, on the question of risk of harm from either, depending how you want to characterize it, stretching the bond between the foster parents and the child, or severing that bond. The 730 evaluator, I think that's Dory Fick, and the therapist talk about the child's resilience.
Yes.
And I'm wondering whether that is evidence that there is either no risk or low risk, or whether that's just evidence that she'll eventually get over it. Is resilience, does that go to whether or not there's a risk of harm, or does that go to whether or not there's going to be a harm, but it will eventually be overcome? Does that harm have to be irreparable? Does it have to be long-lasting? Any thoughts you have on that?
Yes, Your Honor. It is one but many of the constellation of facts for consideration. It's not absolute. It doesn't mean long or short-term harm. It's just part of the equation. A huge part of the equation was the close relationship that the child had with the relative, which ultimately was why Miss Dory Fick concluded that the harm that the move may cause the child distress, but likely not trauma because of that close relationship she had with the relatives. Her resiliency was part of that equation too. So it's one of the many factors. It's not absolute, it's not determinative. And if there is anything that can be gleaned from this court's prior opinion, is that there is no one thing that is outcome determinative. Not the child's resiliency, not the relative placement preference, and not the long-term preference placement in the foster home. That factor may have tipped the scales in favor of maintaining a continuity of care, but the other factors, the close relationship with the relative, the child's healthy mental state, the sisters in the home, being able to grow up with the tribe, the position of every person assigned to the case to be this child's voice, the therapist, the guardian ad litem, and the agreed upon court-appointed expert, all of that evidence tipped the scales in favor of the relatives. And that's really the quintessence of this. The foster parents try to overly complicate a very straightforward, at this point straightforward, legal analysis. Was the evidence sufficient to support what the juvenile court decided? And they try to overly simplify a complex best interest analysis. This is not just about the longevity of the placement. That is a major factor that was deeply considered by the court, which Amici admits. But there were other factors that tipped the scales. Just a few things in response to Ms. McGill.
Before you get to that, let me just ask you a very discreet question, which is, from your unique vantage point in the department, can you tell me whether the department usually faces delays or difficulties in finding equal placement? In other words, what I'm interested to know is, if you know, is there a median or average time it takes to do these things? How long does it take? Because ultimately that may be relevant to the question of whether or not, or how we should evaluate the length of time that's involved in this case.
Certainly, I do have some information, but it is outside the record. To answer this court's question, about 1 to 2% of our cases involve Native children. Of those, about half are placed immediately with local relatives. So we are talking about a very small group of children, and unfortunately, there is, to the best of my knowledge, only one Indian foster home in Los Angeles County. There are a lot of reasons for that, many of which are historical, and the reason for the implementation of the ICWA. And so we face a situation where a child, if not placed immediately with a relative, will be in a non-compliant home during the reunification period in order to promote reunification, but then the resources, which usually are the Oklahoma tribes, a third of our cases are from Cherokee, the next Choctaw. Those resources for long-term care will be in Oklahoma, but as it happened in this case, everybody's well informed of the plan. Here, even though Ms. McGill stated that, and I'm not sure where this comes from, that the relatives were identified in November 2012, that's not accurate. Her clients were well aware that there were relatives that were going to be the permanent home for the child as early as October of 2011. They admit that in an email. We told them over and over again, this child is in your temporary care, and we were ready to make that move.
I'll tell you what, you now have exceeded your 10 minutes, but I'll give you a minute to wrap up.
Thank you. We were ready to make that move in less than 10 months, which is not an insignificant period of time, but well within the time contemplated by the dependency statutes. The delays have been caused by the ongoing litigation, and that's where their interests greatly diverge from Lexi's. This court must affirm the evidence absolutely supports the juvenile court's orders. Thank you.
Thank you, Ms. Norton. Ms.